Thank you very much. Apologies for my appearance, but I've just got off a very delayed train and I haven't quite recovered yet. Hopefully I will in a few minutes. But it's fantastic to be here today. Thank you so much for the invitation. I think that this is indeed a very, very interesting and quickly developing, quickly changing area of digital assets. Life, transactions, commerce, whatever we want to. I'm sure we'll cover all of those. We were supposed to have 3 people today, but we are not able to be joined by one of them, which means that we'll probably be slightly shorter in terms of the panel time, but we'll see how it goes. I'm sure there'll be plenty to say from the people who are joining us. As you've heard, I'm Sarah Green. I've been slightly obsessed by digital assets for the best part of 2 decades as a law professor and then as a law commissioner, and then latterly as an advisor and arbitrator. I'm going to let, slightly unorthodox I know, but I was on a panel yesterday and my bio went on for a very long time and I was cringing, I was dying listening to it. So what I'm going to do is I'm going to let the panelists introduce themselves so that they can decide which bits are relevant to this panel and which bits aren't.
All right, well, maybe I can go on for a very long time speaking about myself. My name is Maria Gritsenko. Right now I'm in-house, but I started my career as an international disputes practitioner in private practice. So I spent, I think, almost 15 years in various international law firms doing actually international arbitration, international disputes, and then somehow got moved in-house, and then that was already 8 years ago, and first I was only doing disputes in-house, but then this evolved, and right now I'm a chief legal officer at EXANTE, which is a fintech, an international investment platform. So today it goes without saying any views which I expressed are my own. They're not the ones of my employer, and I'm speaking as an international dispute specialist and as an in-house counsel, drawing observations about how market participants deal with the issues we will be talking about today. So that's my kind of dual function on this panel.
My name is Keith Murphy. I'm a bankruptcy partner at Baker Hostetler in New York City. And Maria's comment about the caveat about this being my opinion and not that of my firm, I would second that as well, just to cover it. I've spent my career as a bankruptcy attorney. I've done traditional bankruptcy work, restructuring, but for the vast majority of it, I kind of focused on financial fraud, unwinding financial frauds, and specifically Ponzi schemes as well. And there've been a lot of them, and they continue to pop up. Nobody seems to read to the end of the book, which says everybody gets caught and everybody goes to prison. So they keep trying. I will just add, I started to get involved in blockchain and crypto only about 3 years ago from the fraud perspective, because I knew there would be a lot of fraud involved in it, like every other aspect. So I do write on our firm's almost weekly blog post about crypto and blockchain, keeps outside readers up to date on new developments. And also I'm one of the co-authors of a blockchain and Web3 Practicing Law Institute legal treatise. I did the bankruptcy section.
Okay, fantastic. So as you can hear, you've definitely got the experts, or certainly 2 of the experts in the area to hear from this afternoon. What we're going to be talking about is jurisdictional issues, what is distinctive about digital assets disputes, how that maps onto the contrast, if it is a contrast. I think it is, but we'll see if we're in agreement about that, between traditional dispute resolution systems and platforms and those that are specific to digital assets, which I think are particularly exciting and inventive in most cases. We're going to be talking about enforceability, which I think I certainly would regard as one of the biggest challenges. So practical enforcement, what happens even when we have a decision, when we have a dispute that's resolved in legal terms. We're going to be talking about that. And also, if we have time, pre-dispute protocols and strategies that parties can and do implement and adopt. I think the best place to start is I've mentioned what is distinctive about digital assets and digital assets disputes, probably more of the latter. So, Keith, if we start with you, what would you say in your experience? What was your last blog post on?
Oh, I think it was something about the Lazarus Group, most likely.
Oh, okay.
Yeah.
What would you say is in your experience, the most distinctive thing about digital assets disputes as opposed to traditional litigation?
Right. I think traditional dispute litigation, if you're going traditional courts, it's just slower. It takes a long time to resolve. It's very costly as a result. But you have various stages. You have a much more robust discovery process. You file motions to dismiss. You file summary judgment. You go to trial. You can interview witnesses, and it's a much more in-depth process. At the same time, if this is a contract dispute, for example, there's more risk, right? There's more witnesses. There's more evidence coming in to litigation, which either increases your chances of winning or may decrease your chance of winning. So I think that's one aspect of traditional litigation. And of course, in that context, you can't remain anonymous, right? Which is anathema, essentially, to everybody in DeFi and in the space. So if you move on, if you look to the other alternatives, there are alternative dispute resolution platforms and mechanisms, and they provide you with, a level or extreme or some level of anonymity. It's usually much more streamlined. It can occur faster. You can get, hopefully, an enforceable award depending on, what arbitration mechanism you employ. And I think you'll find that the people in the DeFi space and in crypto generally, they may be willing to make that trade-off from the larger litigation to decentralized finance arbitration.
And do you think that's... Sorry, Marie, go on.
No,
I was just going to say, do you find that surprising? Because of course, as lawyers, we sort of, I think, just assume and take it as given that the best system is the one where we have precedent, where we have rule of law, where we have transparency, where we have a certain amount of predictability. And like you, I've encountered parties who would be far more interested in a sort of fast and dirty resolution, if you like, if they have more autonomy over the process. So are you surprised by that difference? Or
I'm not really, because I think everybody has come across litigations in their life and they know it does take a long time. And I think people are looking for speed in the digital sphere, especially because there is volatility involved. And I think that's a major factor. And maybe, in some other types of litigation, it's not. You could be fighting over a ship. Right, it's not going to go up or down that much, but a digital asset might. It could crater within a 2-year period that you're going to be arguing about it. So I'm not surprised at it. They go for speed on these arbitrations, and I think that in this context, it may make sense. But you know what? It's like everything else. You're making a bargain. You're giving up some things in some of these arbitration situations. You might not be able to challenge whether the arbitrator is working on a fair, square deal with you, right? There's others, I'm sure we'll talk about it in a little while, but you may have, unknown jurors, right? You don't have the transparency in the speedier version.
Yeah, absolutely. This is what I said. I think it's something that we as lawyers find quite hard, or certainly I find quite hard to get my head around. Maria, what about you? What's your experience of this distinction?
To be honest, the answer to this question about this DeFi arbitration litigation is a traditional lawyer's answer, which is it depends. It depends on the type of dispute and on the enjeu, on their amounts or the type of dispute. So yes, there are all these completely decentralized protocols, and the dispute has been handled by unknown jurors, and it's deterministic and it's enforceable within the system almost automatically, right? And it's super fast. And you don't know who's deciding and why they decided in this way. And people are mostly doing it for financial gain because, they basically get tokens because they sit as jurors in the systems. So it's very, very far from, our traditional world. And also, it's also very, very far from what would I want as a disputes counsel if I actually have a significant dispute, or if I want for this dispute to be enforceable against some other assets, right, which are outside of the system, because these decentralized protocols don't procure you with an enforceable award unless you select certain rules, but that's a kind of a hybrid category. And if you look at the big exchanges, for example, which crypto exchanges, they don't have these decentralized protocols, right? If you subscribe to Kraken or whatever, I think it's GEMS. It's all GEMS. It's seated in San Francisco. It's traditional arbitration, okay, with some expedited things in there, but still, it's an enforceable arbitration award under your convention, etc. It's not a decentralized protocol. They don't want just some anonymized jurors, completely taking this from out of their control. So again, even in the DeFi space, the answer is it depends on what type of dispute you're dealing with, and how much time and money you want to spend on it, where do you want to enforce it, and then you will look at the options which are available. But you're right that the options which are made available right now in the DeFi space, they're more interested and sometimes more novel than the traditional litigation options. So they do offer this opportunity of getting done in a very short period of time by unknown jurors, but it's not always the most appropriate way of dealing with those things.
Yes, because I suppose, again, in my experience, it'd be interesting to hear if yours is different, that the nature of parties and their appetite for, partly their appetite for waiting a long time. So I think that at the moment, the commercial court waiting list is about 2 years in this jurisdiction-ish. So, even if you're starting a dispute 2 years before, it's likely to be 2 years before you're even heard. I think to a lot of parties in that space, that's just way too much, and it's not at all what they would expect. Have you encountered that?
That's true, no, absolutely, but that's why I'm talking, for most parties, even for big disputes in this space, you wouldn't go to commercial litigation, but you would select GEMS, for example, with expedited rules. So I don't remember exactly how many weeks, but it's still supposed to be quite a short period of time, just not, it's not a semi-automatic process. You'll still have maybe to go to courts if you need some interim orders, right? If you want disclosure, if you want enforcement. So it may not be a very quick process after all, but yeah.
And how much of it do you think is about that? I guess the two, I don't guess, they are definitely interrelated, but how much do you think that is driven by frustration with time periods just for that reason, and how much of it is about the costs? Because again, in my experience, a lot of the parties we're talking about, they're sort of polarized, aren't they? They are huge, like the big exchanges, or they're very small startups who don't really have. What do you think that's? Do you think cost is a big part of it or not? Is it more about the substance of the? Keith, either of you.
I'll just draw an analogy, Sarah, only because I have been working on the Bernard Madoff fraud, right? The biggest Ponzi scheme ever for 17 years now. So we've gotten back billions of dollars for thousands of people. And the fact that I'm here 17 years later speaking to you and still working on the case will tell you how long litigation can take when parties are sufficiently motivated and have deep enough pockets and don't want to return money. So I think in that instance, you get a good idea about maybe selecting an alternative dispute resolution forum is a good idea.
Yes. If you're a small crypto holder, right, you don't want to be engaged in some, expensive litigation, arbitration, of course, and it's much, maybe simple to take the risk of unknown jurors, especially, if not much is to turns on that. But again, the big exchanges, they don't do that. Their customers, right? They go for traditional arbitration, even if modified. The interesting fact, though, that I think in England, a GEMS award was refused enforcement, right? Because that it was contravening consumer protection law. So basically, because you're a consumer and you're forced, I think it was Kraken against Kraken, and you don't have a choice, right? If you own a Bitcoins on Kraken or even 0.0 whatever percent of a Bitcoin, you'll know that you would have agreed to an arbitration in San Francisco. And basically, this guy, he was saying, look, it's very, very disadvantageous to me as a crypto holder to go arbitrate in San Francisco against a mastodont like Kraken, and an English court agreed and said it was contrary to the sort of consumer protection laws. Yeah. So again, it's an additional complication that may arise.
Yeah, I would say Maria has touched on it, a number of them, right? The GEMS, right? Judicial Arbitration and Mediation Services. I have used them before successfully. You get an experienced arbitrator, somebody trained legally. Oftentimes it has a specific expertise perhaps in the area. GEMS has their rules. They've got model proposals and sections that you can put into smart contracts because they were trying to lean in and make themselves available in like DeFi disputes. And their promise, I think, was to have a ruling within 30 days and to have an enforceable arbitral award, which apparently doesn't always work. But I think that that's one option. I know. In 2021, the UK came out with the digital dispute resolution rules, and I think for those they offered elements of anonymity to people who were involved. They also provided that the panel would have the ability to control the smart contract. They could freeze it, and then they could, I guess, appoint others who could take control of that and do other things, I suppose, to enforce the arbitral award. And then I think one of the most important aspects that I learned about it was that the DDRR has an ability to enforce off-chain disputes on-chain, both off-chain and on-chain. So it puts the resolution of a potential dispute on-chain, so it becomes part of the digital world.
Yeah, and we're in the process of possibly revising those rules. I mean, we'll keep the speed. I think there's a view that maybe they need to be more. It was described to me as more crypto bro friendly. They need to be more crypto bro friendly.
What was unfriendly?
I don't know. I have yet to find that out. I'm having a meeting next week where I'll be told, I think.
Part 2.
Yeah, exactly. So they're drafted by lawyers, and I think they look quite accessible, but obviously maybe they just need to be phrased.
Too much
quite
lingo.
Yeah, too much lingo. But I think the objectives of all of these. I mean, that was going to be my next question. What we're talking about, these alternative dispute resolutions, right? So not just non-traditional commercial court litigation. Obviously, we've got arbitration, we've got mediation. If that's ever used in this space. But then we have these processes that are automated to a greater or lesser extent that parties can just choose. So sort of, would you say it's almost a move towards a peer-to-peer resolution, really? If both parties decide if X, then Y, and then you can put it all on chain. So it's... And go on, because you've been talking about, Maria, you've been talking about these jurors, which I think is a really interesting. And I tell lawyers, traditional lawyers, about the jurors that you've been referring to, and
Kleros.
Yeah, Kleros. Yes, and they look terrified at the prospect. So can you tell us what that's like?
I'm not terrified, but I kind of. It's lots of fun. Everything's lots of fun, and especially if if you read, I think a while ago I read, the founders, I think is from Buenos Aires or something, degree of philosophy.
I think that's right.
The whole justification is that it's a random selection of peers to resolve your dispute, because kleros comes from a comparable Greek word, which means, how I think either jurors or some sort of civil servants were selected in Greece, I think, for some purposes. So there is a whole etymology to the word. Please read about it. My brain already filtered out all this information, but it's actually interesting. And it's interesting because it gives a kind of a justification of why they say they come up with it, right? So it's peers. It's the same people who hold, tokens on these networks, and then they decide your dispute. Then, of course, there is the intention, or there is this wonderful ideal world, and there is a practicality. And when you actually read about the conditions and how it works in practice, as we already alluded with Kit, you actually need to spend some tokens to participate as a juror. And then if your decision, and then you make a decision, and if your decision is the same as the decision of the majority, you are rewarded by additional tokens, right? So it's a way of making money. But if your decision is not the decision of majority, then you lose those tokens. So it's a way, it's a game theory, right? It's not quite, so it's not like you are there, consensus citizen, trying to bear the interest of public order and your fellow whatever crypto holders in mind. No, it's more like, okay, will this decision be, you're making a prediction whether this will be a majority decision, basically, because you want to make as much money as possible. So for me, as a trained lawyer, as a lawyer trained in a civil tradition first, and then in the common law, with all these big ideals, etc., that sounds a little bit like, okay, if I just want speed and quick way of solving things for a few €1,000, fine. But if it's something a little bit more substantial or substantive or important, I'd rather go to properly trained lawyers. again, and I was telling this to my fellow co-panelists, I'll be very, very curious to hear if any of you has any experience with this type of systems, like Kleros, like jurors, because I haven't done it personally, but if anybody has got a good experience, I'm very ready to be convinced otherwise, because, we are lawyers, we all learn, and it's, you have to learn.
And I think one of the concerns is that you don't get to know who the jurors are, right? It's completely opaque. And you'll never know their motivations. You'll never know if people have gotten together somehow and tried to be on your case. The goal, as Maria said, was to just try to rule along with the majority, and then you win tokens, right? You stake tokens, you get other people's tokens who decided wrongly, or whatever it was, the minority, right? So it's a very unusual kind of process, but you're putting your faith in there. And I think part of it is that and there's different levels of it. There's different sub-chat rooms or whatever with different expertise, but that you can sign up for perhaps. But I guess part of the theory, you mentioned it earlier, right, Maria, was the game theory. If you expand the number of jurors, and you can select that to a large pool, you're basically hoping that all these people collectively together will eventually come up with the right answer, the right and just answer. So that's what you hope.
It does make me smile when I think about I think it's fair to say, again, be interested in your views, that I think particularly English private lawyers are very conservative. And when I was at the Law Commission trying to change private law in relation to digital assets, just about really basic things like, can you have a property right in any of these things that we're talking about? There was sort of widespread horror, I think it's fair to say. So when I introduced the concept of these game theoretical means of dispensing justice, then the horror was magnified many times over. But of course, this is all deeply rooted in party autonomy. I mean, clearly, this is the really important thing. And when we talk about alternative dispute resolution, obviously that's a huge part of it, and it's the parties choosing their own means. And if they've signed up to these processes, as you said, they're stacking the rule book in their favour by whatever means they wish to. So and every time that happens, takes another case off the listing for the commercial court, and that 2-year wait goes down for those people who are more interested in the rule of law.
The only comment I would add, Sarah, is that on those DeFi platforms, really you don't have a chance for discovery. And so really they're just looking at the contract and the code. They're reading that. And there might be an expert or involved or not, but it's very limited. So you were hoping it's better suited, as Maria alluded to before, kind of like is it yes or no kind of decision. If it's more complex, you're going to find it may not be the best platform for you.
And also coming back to the basics, it's not an enforceable award, right? If you talk about Kleros, for example. So, okay, it's fine if the losing party has enough tokens or whatever to pay for whatever it needs to pay. But if not, you can't really enforce it under the New York Convention, as far as I understand. So it's, you still need...
Not yet.
Not yet. Wait for it. Look, that was what I was going to say earlier. You're mentioning, the horror, this conservative lawyers. But I think now, not to mention, the word that we shouldn't mention, AI and the law, but I think it's all kind of going towards kind of that universe, right? And we're talking about game theory and decision-making. Maybe it's not that far away that, there will be some element of game theory in decision-making and arbitral decision-making, because we'll be using some elements of AI to make decisions, including in traditional, conservative arbitration settings. So maybe it will become more and more acceptable. But again, I think we still have a little bit to go.
Well, that was going to be my next question to you both, actually. Do you both think this is realistically the future of dispute resolution? Do you think it's going to grow, or do you think it's going to stay, what I think is fair to say is probably fairly minority means of resolving disputes?
I think maybe the platforms will get better. I think there's a platform called Mediation, and I thought on that one they were getting success under the New York Convention enforcing awards. I'm not sure how they managed that, but somehow it was. People were electing to perhaps be bound by the decision, right, as part of the smart contract. And I think that's one of the things that parties should do. They should build in a dispute resolution mechanism in your smart contract. So you can talk about things like, what law are we using? What jurisdiction are we in?
Yeah.
So.
I think so. I think that's kind of, again, ideal world speaking, but it's not that hard to do, right? In the context of all this, platforms and tech, you come up with the kind of click, scroll through, and agree thing where you say, this is the dispute resolution mechanism, and then you make sure that this crypto signature is linked to your wallet. So it's, this agreement to a particular procedure is linked to the specific wallet. So it's kind of full traceable. So you try and combine both worlds. So and then you can provide for expedited GEMS rules or whatever you want to provide for, and then state that it's, but choose rules which are kind of enforceable on the New York Convention. I'm not familiar with that platform. Yeah. So I think if it's completely random, it may not be that. I think you can do it. And so to answer your question, I think we'll see more and more of that, but I think it will be sort of in a hybrid form. Again, for simpler things, it will remain on-chain, yeah. It will work. But for bigger players, for bigger amounts, at least if they have good lawyers, I don't think they will leave them just to be completely on-chain and just completely, relinquish any possibility of, settling disputes or tracing or, enforcing under New York Convention, things like that. I think I would still want to preserve this optionality, so I would still want an element of the traditional arbitration. Not court litigation, but arbitration.
Yeah, absolutely. And I think there's no question that the AI is not going to replace us all, which is, the question
I don't think
it's never going to replace.
Maybe in 5 years we'll have the little robots sitting here and, it's fine.
I think, I think they'll be doing a lot more. We've mentioned jams a lot. Do you know, I'm just looking on this. I'm not sure I ever actually knew. I use the word quite a lot, or I use the acronym quite a lot. I didn't actually ever stop really to think what it stands for. Do you know?
Judicial, Arbitration, and Mediation Services.
Which it makes total.
Only because I've used them, so I know.
But so we've been talking about jams, so I apologise, I should have made that clear. It's Judicial, Arbitration and Mediation Services. So could you just say, quick, it's probably to do this a bit backwards, but what's the specific sort of features of jams then, given that you've...
I have to say, I am looking forward to using jams or another platform on a DeFi dispute, but my disputes before jams were more traditional litigation. Right. I found it to be, they have a lot of former judges on there who are very well qualified, and it's in a setting where the parties can agree to provide written briefs that you can provide to the arbitrator. You can provide some evidence if you wish. It's really up to the arbitrator and the parties. Where that takes place, the forum is generally, my experience was in Manhattan because that's where they have an office, and I found the process very good, and generally speaking, in the course of a day, at the end of the day, we reached a mediated settlement. It did not look like that, for example, at 5 p.m. in a lot of those instances. So it's really, we were truly believing something wouldn't settle, and by 9 p.m. it did. So I think it's useful.
So what do you think made the real difference in speed terms then?
In speed terms, it's certainly, when we got to a certain point where we were on the cusp of going into deeper discovery, witness interviews, witness depositions, deeper document expectations among the parties. When you have document requests for admissions by the parties, that starts to get very costly. And depending on when your litigation is and where these witnesses are, either in the company or outside the company, sometimes you strike a nerve, and somebody at the CEO or somebody else at the company says, you know what, I don't really like this. Let's go to mediation. So I think there's different motivations, and that's one of them.
Yeah. Okay. Thank you. Did you have anything to add to that, Maria?
No, I think we've done enough.
Okay, I'm going to change the subject to something that is sort of my pet subject, but also something that makes me want to lie down in a darkened room when I think about it. And that is determining jurisdiction applicable to disputes. So one of the real issues with digital assets is, of course, where are they? What are they has been a question for years. I think we're sort of getting, in legal terms, to an answer to that now across jurisdictions, whether that's through common law or any form of code or legislative reasoning. But I think there are still outstanding questions, very difficult questions, about where those assets are for the purposes of applicable law of jurisdiction. So where does the dispute get heard? What law is applied? Because, of course, depending on how you see digital assets, they either have an indeterminate location, or they're everywhere, or they're nowhere. I don't know. I've heard all of these things said before when we talk about digital assets. So, what do you think is? Have you got the magic answer for me? I've asked this question of many people. How do we do this? What's the best way of dealing with this very thorny question of jurisdiction and governing law?
Okay, I think for the lawyers in the room, you remember these words. Like there's concepts of jurisdiction in rem, quasi in rem. That's at least what we use in the States.
Yep.
So in rem, you're asking the court to take jurisdiction over a particular asset, for example, to determine ownership of that asset. And that's one reason that's one basis you could show the court has jurisdiction. Quasi in rem is a situation where you're using an asset to kind of determine people's rights with respect to it, or some other related property dispute in connection with that asset. And those are some typical ways you might get jurisdiction over an asset. Sarah, as you said, it's not a car, it's not a ship, it's not anything it's not tangible. It exists everywhere and nowhere, right? There's no tangible manifestation of a digital asset. So there have been various theories. You have a theory of the domicile of the asset holder would be a place where you can establish jurisdiction, right? And that seems to be the most popular theory, I think, at the moment, probably by far. Another theory is a key theory, which is you look to where the key is for the digital asset, and that's the location that you could establish jurisdiction. Another one is a node theory, which is basically like on any node where this blockchain ledger exists, that you have jurisdiction there. But that's completely unworkable, right? I mean, can you imagine, Maria, going all over the world?
Yeah, it's so much fun. I'll go back to private practice just so I can go, and litigate in every jurisdiction. Sorry.
No, that was it.
I think in the UK, England is doing its traditional lovely thing of, we'll let the courts figure it out, right? So we have now the Digital Assets Act, right? So we do know that digital assets are not assured in possession, it's not assured in action. It's a third category of assets, but it exists. So it's definitely property. So that's a good start. But how you kind of go after it and determine where it's located, that's left up to the courts. And I think until recently, and I think still now, the most popular theory is residence or domicile of the key holder. But recently, I think the Law Commission came up with a control proposal. So it's where the control over the keys is. And of course, then the question is, what is control over the keys? And again, coming back to the little hypothetical of you're holding Bitcoins with Kraken, if you're just, a client of the Kraken crypto exchange and you bought some Bitcoins and they are still lying with Kraken, basically they are part of this big omnibus Kraken account, right? You basically have a contractual claim against Kraken, but Kraken is the one who controls the keys to this wallet, to these Bitcoins. But if you then download those Bitcoins to your ledger, as far as I understand, then you become the control of the keys, right? Because this is lying, on your little ledger that you don't want to show anyone and ever lose or forget where it is. So you're the one controlling the keys. And that actually may play a significant difference in how to approach litigation, where you go against, Kraken, where you go against this particular person who controls the keys. But I don't know how it's going to play out in litigation. I understand that in fraud cases, there's been a recent fraud case in English court, and they still said that it was the residence of the alleged victim. I think Smithers, was it? I forgot the name. It was recently, a couple of months ago. So it's still the domicile residence. But it's in a particular context of fraud. But if you're talking about more, commercial context, then should be talking about control now, which is, raises other type of issues.
There's a case that I'm just vaguely familiar with, but it was a question of the BVI court, whether the BVI court could establish jurisdiction over digital assets. And it was a multi-sig wallet, so there's really very little connection at all to the BVI court, but the administrators were trying to put jurisdiction there. And the way that they figured it out, or that the court decided, I believe, is that what was in common with all the multi-sig holders was that they all utilized like a service provider, a common service provider that was based in the BVI. And based on that, the BVI court said, I'm taking jurisdiction. So I think courts will be creative in the bottom, in the end. They want to help.
Lawyers must be creative, to kind of try and pin this.
I mean, do you think anyway that it doesn't matter quite so much what the rule is? Because I mean, for non-lawyers who, understandably would never really have thought about this, when you've got a cross-border dispute, it matters very much for all sorts of reasons where that dispute is going to be heard and what law is going to be applied, more to the point, because parties have a certain expectation, they get legal advice based on a certain jurisdiction's laws, and then of course if it's decided under a different law, that can be very bad news. And for traditional things like ships and aeroplanes and gold, traditional tangible things, that's usually determined on the basis of where that thing physically is. And that's for practical reasons. Well, I think it's partly political, sovereignty, jurisdictions having the power to say what happens to property within their borders. But it's also practical enforcement, right? So it makes sense for it to be determined in the place where the thing is. But of course, and I think this fits in with what we've just saying now, it doesn't matter so much with digital assets where they are, because it's about the control and it's about the enforcement possibilities, or maybe it is just about having a certain rule. If we all knew it was going to be the domicile of the transferee or the transferor or the sort of HQ of the main server, whatever it is, whatever the setup is. Yeah. I mean, I've said when I was at the Law Commission still working on this project that might actually just be the best way to do it. So at least we've got some certainty and parties can structure their agreements accordingly.
So did you work with the Law Commission on this? Yes,
I left before the end of the project, but I'd started the project there, yeah.
So what was their thinking? What is control? Do I understand it correctly?
Yeah. So obviously control is fact dependent. It depends on the particular setup and the platform, but it's really what enables you to do so it's linked to the question of, can you have a property right? If you have a digital asset, so we go all the way back to sort of Roman law concepts. If you're the owner, you are the person or the entity who gets to use, abuse and dispose of those assets. And whatever allows you to use, abuse and dispose of a digital asset, if whether that's the private key or whatever is in the is coming down the track for however else that's going to be done, then that is what gives you effective control and therefore enforcement ability. So
I feel like most countries, most courts, most people probably want to ascribe to that concept, right? That this is a property right that you have, that you should be adjudicable in some fashion. And I think even though digital assets are a new form of asset, there's still the concept behind it is kind of similar, right? So courts make every effort to try to apply existing law framework to these assets, and sometimes it doesn't always work, right? But maybe the answer will be ultimately when you can start looking to some countries' conflicts of laws rules, right, and see what happens. And maybe those are rules that could be rewritten. They don't need to rewrite their underlying law, but you could say, but what if there's a conflict? Is there a question of comity, right? Do I have to defer to another jurisdiction's laws, right? And some countries don't even allow crypto. Right. So what do you do in that instance, right? If you're trying to enforce an award in a country that doesn't allow crypto assets, they're not going to help you.
No, and there are also some jurisdictions who say if there is a dispute, no matter what you've put in the contract, we're deciding it.
Right. I think actually Hong Kong, I believe, may not even provide you the proper enough assistance, right? They do to a certain degree, but maybe not to fully assist you if you have an arbitral award.
Yeah, there are differences. Right, I have got an eye on the time, and actually that segues quite well into what we'd planned to talk about next anyway, which was the types of disputes that we're seeing in relation to digital assets. So what are the kind of things that are getting as far as a need for dispute resolution in your experience?
Well, look, the most popular, of course, is the crypto fraud or alleged crypto fraud, right? So, your Bitcoin has disappeared, or your wife, has nicked your Bitcoin or something like that.
It's quite often that, actually, isn't it?
I know, right? I wonder why. But yeah.
It's a remarkably common fact.
So that's honestly that's most what it is. I think we'll see more and more because crypto is more and more getting used as a collateral as well for various financial operations. So we'll see disputes in relation to that as well to enforce basically collateral provisions and collateral commitments against crypto assets. So I think that's kind of, for me, those are the two main.
Like contract, obviously there's contracts, what you're discussing there, that's one. And then with respect to the stolen Bitcoin example, you've got, concepts of restitution theories and unjust enrichment as causes of action potentially. And you also, there are also torts, right? There are cases which ask whether a VASP or any other kind of service provider may have fiduciary duties to its clients, right? And so you may have a tort claim in that instance, and I think that has been recognized, liability, or at least the obligation of the service provider to provide assistance when somebody's assets have gone missing. So the failure to do so may be a failure of some obligation of theirs. So it's all being tested.
Yeah, and it's quite, it feels to me that well, I think about 5 years ago I would have said it's in very early stages in terms of the actually seeing these claims. I think for a while we were anyone who was interested in it was thinking speculatively, if this came up, how would we deal with it? Whereas of course, fast forward 5 years, and I think we do have quite a lot across jurisdictions. I now think we've got quite a lot of authority that, well, in digital assets terms, quite a lot of authority that we can look to. And the problem, of course, with doing it that way, despite being a dyed-in-the-wool common lawyer, is that, of course, you just have to wait for the right questions to come before a court.
Right.
So, very different to a civil law system where you can just say, well, this is what we want to do about it. So parties, certainly in England and Wales, are still left guessing to some extent, but I think that the boundaries of what you might expect as a litigant or a party to any form of dispute resolution has narrowed a bit.
Right, I agree. Yeah.
I think, there are a couple of recent cases that may be, interested in terms of, narrowing down this remit. There's a very recent case, I think it's Win, where, so now we know it's property, right? Digital assets is a third type of property. But the court in that case said that conversion is not available for that. So it cannot be treated as a tangible property, basically. So you can, I think, claim unjust enrichment, restitution, and what's the third one? Unjust enrichment, restitution, and
there's proprietary restitution. They did. They didn't say you could have it, but you could.
You could. So basically, that's what's available to you, but you cannot consider it's a tangible property, so you cannot go for the tort of conversion, basically. So I think it's a decision from March of this year. So again, this narrows down a little bit. So the next set of lawyers who will be arguing, they will be going, for
different cause of action.
The different cause of actions.
Right.
So now you kind of.
I think the court still left it open, right? Though,
yeah,
so
they left it open.
Come back to us.
Come back, but you kind of okay, let's not forget doing this other causes of action, at least in the alternative. And then coming back to what Keith said earlier, that now the provider, they may also have some obligations. We don't have a positive ruling that they owe fiduciary duties, right? But there was a case a couple of years ago where a victim of a fraud, and the provider recognized it was fraud, basically was, trying to claim back the cryptocurrency. And, the cryptocurrency went from his wallet to, through a chain of wallets, and then ended up being kind of cashed out. So
the lawyer.
The lawyer, that's one. And so in that case, the exchange effectively, there were some signs that these assets were tainted. Their KYC and ML was not perfect, basically, and the court was quite critical of them that, they didn't have a good faith kind of defense, etc. So I feel like the court was very close to probably telling them they should have, given back the assets, but the claimant didn't manage to trace the assets. So the methodology he used, or his expert used, was flawed. And basically, for me, as coming back to my in-house counsel role, as a very practical points, is that will be one of the points, right? How do you trace these assets going through various wallets and being commingled together, and being pulled together with other bitcoins or other cryptocurrency. And there are various protocols now and various analytics tools. But in the lawyer case, for example, I think you used 2 of those, and they come up with.
They did not impress the court.
They didn't impress the court, basically. I think the court said the methodology was chaotic and inconsistent.
Yeah, shambolic.
Shambolic or chaotic or something. And basically 2 of these protocols, each of the protocols resulted in a different kind of outcome.
Yeah.
So the guy couldn't even calculate properly, couldn't trace properly the assets, and the court was like, well, okay, there were AML, anti-money laundering failures, yes, the exchange should have known, etc., but you didn't manage to prove that your cryptocurrency went from this wallet to this wallet to this wallet. Your expert was chaotic and shambolic, and so he lost his claim. So I guess that's kind of a very practical lesson, that if you have a big amount of cryptocurrency which goes missing, get a good expert. Get a good expert.
Although I suppose you could say, I am conscious of time, I'm going to finish now, but I suppose you could say that's not necessarily specific to digital assets. I mean, you could get a poor expert, get a shambolic expert of any type.
I will add, though, I'm involved in a separate Ponzi scheme representing a receiver, which does involve crypto.
Okay.
And we had success in getting back some of that crypto and reaching out to some of the exchanges to try to get that back or get a freeze on it, because we were able to employ experts that showed that this was the debtor's money. Right, and fortunately, it wasn't involving a mixer or anything else that complicated. But it's an art, it's a science and an art to trace this money. And when you can make a sufficient showing, this was in a U.S. district court in New York. The court granted our relief. So it's possible. Some of the other panels were talking about LLMs and frauds and expanding the craziness of how fraud may occur in the future and how it would be impossible to trace. So that's terrifying. But we had somewhat of an easy case there.
Well, I think it's just going to get better. And it's like anything, isn't it? The better the nefarious activities get, the better the remedial.
Right.
And it's like when I was a kid, I remember car firms used to employ ex-car thieves to test their security systems, and now, of course, the same happens with white hackers, and so I think we'll get there.
Yeah, we'll get there.
I'm always an optimist. We've got 1 minute left if anyone has any questions, and if not, yes.
To touch on one of the aspects that you mentioned about jurisdiction, right? To add to the complexity, I want to make one point and then a question upfront. So, to add to the complexity, decentralized autonomous organizations, which is actually not human-driven, adds to whatever you just said. Oh, yeah, okay. They want me to start again. Sorry. Okay. The aspect you touched on about jurisdictions, right? So the key element in the complexity is that decentralized autonomous organizations, DAO, is one layer on top of it, where human is actually not involved, and actually means you can't go and sue anybody in any jurisdiction, number one. Number two is the Web 4, realistically speaking, which is bringing in the concept of decentralized autonomous AI agents. That's another one. But the question here is this for you, right? So, I mean, that's just a top up to what you said. But question is, lawyers and solicitors, actually to everyone here, right, who are from solicitor firms, there are a lot of auditing happening of the smart contract, which is the heart of the blockchain here. In case that smart contract actually ends up ruining or draining a client's funds or firm's funds, who is that the responsibility? Who the negligence goes to whom actually in this case?
Okay, I can take
You take it, because I was going to say the third panelist, that was his perfect area.
So, I mean, basically, obviously, it's a locus of liability question, and that is very difficult with AI because it doesn't have legal personhood. So the answer is very difficult. I will say that. I will say what Maria said at the start, that, it all depends on its situation. We did look at this at the Law Commission, so we did do a scoping paper on DAOs and legal liability, and said it would depend in a given case what the corporate attribution rules would be, depending on how the DAO was set up. I mean, clearly you have to link it at some point to somebody with legal personhood and a bank account, or an insurer, or preferably both. What was your second point? Sorry.
It's about the smart contracts. So if the solicitors are reviewing the smart contracts and the ecosystem of a transaction, and that smart contract ends up draining the client's funds or whoever is fund.
I know what I was going to say. Yeah. So So taking that locus of liability point further, we've also looked at this. It's another UKJT publication. Keith mentioned the UKJT DDRR earlier. We've just done a statement on AI and civil liability. And although, again, it doesn't give definitive answers, because at the moment I don't think we can, what it does do is step through the, rather than just me saying as I have to, given the time now, it's factually dependent, it does actually set out, it's available online on the UKJT website, it does actually set out suggested indicia of what would give liability to certain parties depending on certain fact situations. And I think, similar to what Keith was just saying about these things are new, but there's really nothing new under the sun. Actually, of course they're new, and of course DAOs throw up all these difficult questions, but actually we do have the toolkit as lawyers, and it really is a question of analogy. It's not really thinking about anything that is brand new. I've talked too long in answer to that. So I really should finish it there, because I'm aware it's the end of the day. So thank you very much to my panellists. I've learned a lot, so I hope you've learned something as well. Yeah, we're done.
Thank you. Thank you. Thanks.